Today is Thursday, September 26, 2024, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Kizh peoples. Commissioner Topshin, will you please lead us in the Pledge of Allegiance?
Sure, thank you, Chair. Please rise and repeat after me.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. We're excited tonight to have three new commissioners joining us, and we're also excited to welcome Councilmember Heilman to our meeting this evening. He's with us to administer the oaths of office to each of our new commissioners, and we will start first with Alex Paris.
First of all, thank you all for your service. We're so lucky to have all of you and so lucky to have our new commissioners here tonight. So Alex, please repeat after me. I, Alex Paris,
I, Alex Paris,
do solemnly swear
do solemnly swear
that while serving in the office
that while serving in the office
as a member of the Rent Stabilization Commission
as a member of the Rent Stabilization Commission
of the City of West Hollywood,
of the City of West Hollywood,
that I will support and defend
that I will support and defend
the Constitution of the United
the
States
Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United
to
States
the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well and faithfully discharge
that I will well and faithfully discharge
the duties upon which I'm about to enter.
the duties upon which I'm about to enter.
Congratulations, you're official.
Thank you so much.
Congratulations. We will next go with Caitlin McCafferty.
All right, you already got to see how we do this,
Yeah, I'm grateful to not go first.
so please repeat after me. I, Caitlin McCafferty,
I, Caitlin McCafferty,
do solemnly swear
do solemnly swear
that while serving in the office
that while serving in the office
as a member of the Rent Stabilization Commission
as a member of the Rent Stabilization Commission
of the City of West Hollywood,
of the City of West Hollywood,
that I will support and defend
that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well and faithfully discharge
and that I will well and faithfully discharge
the duties upon which I'm about to enter.
the duties upon which I'm about to enter.
Excellent, you're official. Congratulations.
Thank you so much.
Congratulations. And now we'll welcome Rena Goldman.
Thank you. Please repeat after me. I, Rena Goldman,
I, Rena Goldman,
do solemnly swear
do solemnly swear
that while serving in the office
that while serving in the office
as a member of the Rent Stabilization Commission
as a member of the Rent Stabilization Commission
of the City of West Hollywood,
of the City of West Hollywood,
that I will support and defend
that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well and faithfully discharge
and that I will well and faithfully discharge
the duties upon which I'm about to enter.
the duties upon which I'm about to enter.
Excellent. Congratulations. You're
Congratulations and welcome to all three of the new commissioners. We're really excited to have you and thank you for being with us, Councilmember Heilman. We'll wait just a moment for all the new commissioners to take their seats. Welcome. Thank you. Mr. Secretary, may we have a roll call, please?
Commissioner Goldman? Here. Commissioner Kirby's?
Here.
Commissioner McCafferty?
Here.
Commissioner Paris? Here. Commissioner Topshin?
Here.
Vice Chair Rory? Here. Chair Bass?
Here. We have a quorum, and the first time we've had 7 members at this dais since February, so I'm very excited about that. Has everyone had the chance to review tonight's agenda? And before I get a motion on that, there is one change I would like to recommend, and that is under our appeals, one of the parties from the first appeal will not be in attendance this evening, so I'm going to suggest that we switch the order of the appeals and do the second one first. I have the numbers here, but I think it's pretty self-explanatory what I just explained. So if that change is
I'll
welcome.
move as amended with the appeal D4865 to proceed D4846.
Is there a second?
Second.
Mr. Secretary, may we have a roll call, please?
Commissioner Goldman?
Oh, you're voting yes or no?
Commissioner Kirby's?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris? Commissioner Topshin?
Aye.
Vice Chair Rory?
Yes.
Chair Bass?
Yes. The agenda is approved. Now we will move on to the minutes. Has everyone had a chance to review the minutes from the August 8th meeting?
I'll move them.
Before you move them, one change on page, it's the last page of the minutes. It's page 5 of our packet. Under items from commissioners, I'd like to change Chair Bass welcomed the newly appointed commissioner rather than thanked. With that one change.
So with that change, I move them.
Second.
Mr. Secretary, may we have a roll call, please?
Commissioner Goldman?
Aye.
Or you may, I think you may abstain just due to not being present at the previous meeting.
Oh, okay.
Commissioner Kirby's?
Aye.
Commissioner McCafferty?
Abstain.
Commissioner Paris?
I think I have to abstain because I was present but not up on the diet.
So that's an abstention?
Yes.
Okay.
Commissioner Topshin?
Aye.
Vice
Yeah.
Chair Rory?
Yes.
Chair Bass?
Aye. The motion passes.
Chair, real quick, may
Please.
I interject? For all commissioners, but especially new commissioners, if we can use our mics when we're answering questions, so it gets recorded for our WehoTV and for anyone watching online. So that would be great. Thanks.
And thank you to our legal counsel for that advice. Just so you know, there's a little button here, which I advise people to use liberally to turn on and off as you are speaking. It's better to keep only one mic on at a time if possible. Sure. But it's easy to forget to turn them on too, so we'll remind you. Thank you. Let's see here. Item number 7, public comment. Do we have public comment this evening?
Yes, we do. We have Eric Bouchard here with us.
Okay. As you approach the podium, if you could just make sure to state your name and city of residence, and then you will have 3 minutes to speak.
Okay. Eric Bouchard, City of Residence, West Hollywood. Congrats to the new commissioners that are joining tonight. So I'm an owner of a duplex with one rent-stabilized unit and owner-occupied. I live in the other. First off, I just want to say, I'm very supportive overall of the rent stabilization ordinances in the city, and I'm not an angry slumlord that's here to protest them. But I do want to ask the commission to consider on security deposits is determined. The current process involves looking at bank rate and selecting the highest rates from those institutions. And so what this essentially creates is a scenario where on an annual basis, landlords have to move funds around, close bank accounts, have to shift the money into a new account to chase the highest rate that's available. And if I don't secure the highest rate, then I have to eat the difference. So the rate, I think, for last year was around 5%, which is much higher than what large institutions, like, for instance, this is a mailer that I just got from Amex that is advertising 4.25%. So if I had moved my money into here, then I'd have to eat, paying an additional payout to my tenant because this is not the highest rate that the city established. So few ideas that I would just like to propose for considering new methodology. There's using the national savings account rate, which, full disclosure, is probably way too low. It's below 1%, but it is the national average. Or use an average from banks located within the city of West Hollywood. Remove the city. The next would be removing the city altogether from establishing the rates, and just set a stipulation that if the tenant requests the funds be moved into a rate that is more favorable to them, that the landlord do so. Or the final recommendation would just be to disclose in advance every year the banking institutions that are going to be used, so that it's not a surprise at the end of the year which banks have been selected and what the rate has been determined at that point in time. And that's it.
Great, thank you very much. Mr. Secretary, do we have anyone else?
No one else at this time.
Great, thank you very much. We'll turn to item number 8, the city manager, the rent stabilization manager. I gave you promotion. Your report.
Thank you. Good evening, commissioners. It's really nice to see you all after a brief recess since our last meeting, and a very warm welcome to Commissioner Paris, Commissioner McCafferty, and Commissioner Goldman. I really look forward to working with you, and I just wanted to make sure to extend my warm welcome. In terms of the look-ahead calendar, this evening we're going to be hearing appeals D4846 and D4865, as well as a discussion on the rescission of resolution RSC 23622. On October 10th, we'll be hearing appeal D4869 and appeal D4876. On October 24th, D4851CD and D4831CD. On November 14th, D4884 and D4877. On December 12th, D4916 and D4889. On December 26th, D4804CD and D4689 CD1. And finally, in 2025, on January 9th, D4750 CD. That concludes the manager's report. Thank you.
Thank you very much. Are there any questions for the manager at this time? Seeing none, we will move on to our appeals. It is item number 9. We have 2 appeals before us this evening, and the first one is going to be D4845 as we changed the order, as we approved our agenda. Do we have a representative for the tenant and the landlord present?
Yes.
Okay.
The landlord is joining us via Zoom.
Great. First, we'll hear a staff report from our legal counsel.
Hello, everyone, and welcome to the new commissioners, and welcome back to the rest of you. My name is Kellen Martz, legal counsel to the Rent Stabilization Commission. I want to note in both of these appeals, in the conclusion section, there is a typo where it says that, let me just get there real quick too. So the recommendation as written says commission shall affirm the hearing examiner's decision denying the rent decrease application. It should say decision granting the rent decrease application, and that's to both of these. All of the other parts of the staff report are the same. And so in D-4865, this is a matter with tenant Alice Cutler, filed for a MAR, maximum allowable rent determination, along with whether the landlord has accepted and retained rent in excess of what is permitted by law. The tenant has resided in the property since November 2010. Hearing examiner found that the unit's initial rent was lawful, but all subsequent rent increases were in violation of the RSO. This was because the unit had not been re-registered as required by law. Because of that, the base rent was found to be $1,200, which was the rent that was the initial rent when the tenant moved in. The landlord said that all rent increases were illegal, which resulted in an overcharge of $13,824.11, which was due back to the tenant because of this decision. The landlord has appealed, stating that the rent increases were in line with the legally allowed increases permitted by the City of West Hollywood, and tenant was aware of those increases and agreed to them. There was new evidence submitted after the hearing, claimed it was not available at the time of the hearing, but they discovered it during an audit. Staff believes that that evidence was available at the time of the hearing. It was just not found, and they didn't look through their records, so it should not be considered. And in this case, staff found that the document that they submitted was an estoppel certificate, a 3-day notice to the tenant, and a re-registration form. Those do not contradict the hearing examiner's findings, nor do they assist in the appeal at this time. And so with that, staff recommends that the commission affirm the hearing examiner's decision.
Thank you very much. Any questions for our legal counsel at this time? Commissioner Kirpies?
I just have one, in terms of, so once the landlord were to become compliant, so they filed their registration in December, I think, in this case. So once they have reimbursed, or the tenant has been made whole from the amount, can the landlord from that point forward look back, and the current rent could be brought up to whatever the AGAs would have allowed over time?
They would need to do a rent increase from the rent as of today. So the base rent, in this case, I believe is $1,200. They're only allowed to do the rent increase that is available each year. So they can't do a look back.
So let's say, I don't remember what it is this year, let's say it's 3%, I don't remember what it is, but so they would only be able to go up 3% after duly noticing and all that stuff?
That is correct.
Okay, thank you.
Any other questions? Vice Chair Rory?
2 questions for legal counsel. One is, could you maybe elaborate a little bit on what the policy objectives are for the registration requirement? I think that might be good for the tenants and the landlord to hear before both appeals tonight, and for everyone listening in. And then the second question was, in terms of staff's recommendation for this appeal, well, I'm going to save that question for after I hear from both, but I wanted to ask about whether there's a recommendation for a credit on the rent application, the 1593 number that's currently before us, whether that would be a credit situation, or the landlord could potentially have to give that back, and what the current order is, and whether we could modify that.
Yeah, excuse me. So to the first question, the registration, I'll let the manager add in if there's anything else. But I believe the biggest thing is just to be able to track and to know which units are in rent stabilization and which are not. There's a lot of laws beyond just this process that apply to rent stabilized units only. So if someone calls in and says, I live in X unit, there's a system to track those and to know which laws apply and those type of things. So anything else?
Yeah, I would just add to ensure compliance with the RSO generally. So we also, obviously track rent amounts to ensure that landlords are respecting the annual general adjustment, and also the amenities that are included. If there's ever situations where an amenity is reduced, we can have that information from the get-go in the registration system.
And as to your second question, I'm going to look into that while you're deliberating and taking testimony. But yeah, I will defer the answer to that for just a bit.
Any additional questions? I have one, and I'd ask the staff to talk to us about the re-registration process. Obviously, the record does not include any proof of re-registration from either the tenant or the landlord. Does the city keep those records as well, and how is that factored into the hearing examiner's process?
Yes, so the city does have those records. It's included in the assembly of documents, which are provided to the hearing examiner prior to the proceeding. It's also included on the listing of raised issues, whether the unit was re-registered and what the date of re-registration was. So that is available to the hearing officer.
So if neither a tenant or a landlord had a copy of that, the city would provide it to the hearing examiner should it have been filed?
Yes, that's automatically provided. Mhm.
Thank you very much. Any additional questions? Seeing none, we will go to the testimony portion of this. We will start with the landlord, because who's with us via Zoom, because they appealed, and they will speak first. So you have 5 minutes to speak. You can use, I see two of you are here. You can speak, you can share the time, you can choose who takes how much time, but note that your 5 minutes can also be divided to provide your testimony as well as a rebuttal. So if you would like to do 3 minutes and 2 minutes, 2.5, 4 and 1, however you'd like to divide that time, it's up to you. You're allowed to do that. So if you could just, when you start, give us your name, your city of residence, and tell us how you'd like to divide your time. And just so the respondent knows, the tenant, you are not allowed to divide your time. You'll just have 5 minutes when you speak. So with that, I'd invite the landlord to provide testimony.
Hi, good evening. My name is Denise. I am the general manager for this community in West Hollywood. Regarding Alice Cutler, we completed the appeal because of the rent registration that we submitted. Due to the records, we found that the last registration was submitted in 2023. In the
Denise,
appeal,
Denise, can you stop for a moment? Just tell us how you want to divide the time so the secretary can clock accordingly.
yes, I'll be completing the appeal for the 5 minutes.
Okay, thank you.
Of course. During the appeal, we did submit all the documents that we found. And during the conversation, it was noted on there on the record that she did make a mistake where she stated that her rent was $13.50 at filing. And we submitted the documentations accordingly on September 1st. Her rent went from $14.96.34 to $15.41 with 23 cents. After that, we submitted another rent increase in March 2023 for the allowable 3% from $15.41.23 to $15.93 with 47 cents. We did not do any rent increases or late fees during COVID times as it was not permitted. And we only increased accordingly to the effectiveness of the law from the West Hollywood. In addition to that, we have all the records as far as the ledgers, the previous owners' rent increase, our rent increase. The estoppel that we found was founded in an audit that we completed through the previous employees that are no longer with the company. We did have to find and through their archives and emails in order to be able to find those records. And that's all the documents that we submitted to the appeal noted in the email that we sent out.
Thank you. Do you have anything additional at this time?
Not at this time.
Okay, Mr. Secretary, how much time do they have left?
3 minutes, 27 seconds.
So after the tenant speaks, you will have 3 minutes and 27 seconds to provide a rebuttal should you choose to do that. So now I would invite the tenant to approach the podium, and you're welcome to take your 5 minutes, but likewise I would ask you to state your name and city of residence for the record. Thank you very much.
Hi, I'm Alice Cutler, City of Residence is West Hollywood, and I actually don't have anything to add, but she is correct that originally I had made the mistake that my rent when I first moved in was $1,200. It was actually $1,350, but I told them in the hearing, so they actually made that note in the hearing that the original rent was $1,350. But that's, I don't really have anything else to add to that.
Thank you very much. And I neglected while the landlord was speaking to ask the commissioners if they had any questions. Forgive me, this is my first time as chair for an appeal, so I'm messing up. But does anyone have questions for the tenant while they're still here? Some of the commissioners might have questions for you, so give it just a moment.
Sorry. Yes, so my question, So when you moved in 2010, I believe, that was your rent, was $13.50?
Correct.
Okay. And you provided that information to the hearing examiner?
Yes. So when they originally asked my first rent, I thought it was $1,200, but then when I realized it was $13.50, I corrected it with them. So they know that when we had our hearing.
Okay. So, and I'll need to talk more with our legal counsel and our commission, but just bear with me for a second. In a scenario where if the chart I'm looking at in the decision was that the decision was made based upon a $1,200 initial rent. If we were to change that to $13.50 and redo the calculations, do you think that that would be fair?
Yes.
Okay. Thank you.
And Commissioner
Chair,
Thompson.
no, thank you. Very quickly, I think you testified that you don't have a copy of the lease, correct?
Not the original lease.
Not the original lease,
Yes.
but do you recall signing one?
Yes.
And do you believe that the landlord had the copy, kept the copy?
Yeah, I actually, the one from 2010?
Yes.
I actually contacted him because I couldn't find it. And he didn't have it available right away. He said you might be able to get it, but he didn't have it on him at the time. And it was 14 years ago, so I couldn't, it was too far back for me to get a copy of the first check that I had written.
Okay. And what was the subsequent agreement signed? When did you sign the subsequent lease?
I think it was a year, what's it? A year later? Yeah, it was a year later. Yeah.
A year later, in 2011 or 12?
Yes,
Okay.
2011.
2011. And was that a copy of that lease provided to the hearing?
No, I didn't have that one either.
You didn't have that one either?
No.
Okay. But do you remember what the amount was recorded in that lease? I just wonder. It may not change anything.
It would have been somewhere between 13, 15, and 14. I couldn't tell you off the top of my head.
Okay, thank you.
Commissioner McCafferty.
My question is about Exhibit 4, the email from property management that has the incorrect move-in rent crossed out and then 1,200 written, and then an email talking about the mistake and then having the property management company saying, yes, the 1,200 is correct.
Commissioner, which page are you looking at?
Oh, sorry.
On the top right?
131 and
Thank you.
132. So I guess I'm not sure who my question is for, staff and the applicant probably, is just what is where did this 1,200 number come from? And then a little bit more about this email kind of confirming it.
I can answer that. So the 1,200 was completely my mistake. I had in my head that I originally paid 1,200. Then later went back and realized that was a mistake. This was after I'd already spoken with the city of West Hollywood about this. The reason for the cross out, that confusion, is that I originally was sent an application and they said, is this was your initial rent, and it was the rent I was paying at the time. And I misread it and said yes. And then I later went back, looked at it, and I said, no, this is the rent I'm paying now. That's not my initial rent. So then that's why there was a change. But then the number I gave was the wrong number. It should have been $13.50, not 15, I can't remember what it was, 15 and change. Yeah.
Okay, thank you.
Thank you. I see no other questions. Thank you very much. And we will go back to the landlord at this point in time. And like happened with the tenant, when you're done speaking, the commissioners may have comment or questions for you. But go ahead.
So in conjunction to what she was saying, we actually ended up finding the estoppel certificate that she signed a year later, as we've been digging through the previous employees' emails and computers to try to find any additional information. We did have that information. We were not able to provide it at the time because we've been trying to locate any additional information that we could to supply over. So we do have that documentation if needed to be provided.
Thank you. Do you have anything else?
Not at the moment.
Then I will turn to the commission. Commissioner Topchin.
Thank you. Yes, good evening. I think a couple of questions again regarding the lease. Did I understand correctly? The ownership remains the same. Is the management changed? Is that correct?
The management's the same, yeah.
Oh,
It's
the
just we
management is
changed
same.
offices. Yes,
Okay.
the ownership is what changed recently.
Okay, so then I got it vice versa. Were you able to, so do you have a copy of that lease, the one that 10 doesn't have? Since,
Sorry, I apologize. For the estoppel that she signed a year later, yes, we do.
not the estoppel, the original lease agreement from, what is it, 2010, when the 10 moved in?
I don't believe so, no.
Okay, so you also don't have a copy. All right, so, but you have a copy of the estoppel, the recent one?
Yes, it was signed in October 31st of 2011.
So, and do you recall the amount of the rent?
Stated on the document, it says that her rent was at $14.96 with 34 cents, and the deposit was for $13.50.
1350. Okay, got it. Thank you very much. Nothing
Of course.
further.
Commissioner Kerpes.
Thank you. So when you just spoke in your first segment, so I'm trying to understand, it sounded to me that you were speaking mainly from 2023 when the registration was filed to present and the increases of rent. My question really is, and I think the question for the commission is, was there a registration form filed from the start of the tenancy? Since the start of the tenancy, the only the form that's been filed so far, correct, is the 2023 registration form for this tenancy that you're aware of.
Yes, I don't believe we have her original one. It was not given to us during the due diligence of the community when we were taking over the property. We didn't have the original one, and we did submit the re-registration in 2023.
Okay, when you realized that there wasn't one on file, you filed one.
Correct.
Okay, thank you.
Any other questions from the commissioners? I have a couple for you. So you mentioned you found these records after looking. Who had access to those records, and why were they not available before the hearing examiner meeting?
They were in an employee's files. So there's certain employees that unfortunately are no longer with the company. And a lot of the records were found in their computer emails and other share folders that we don't have access to, specifically me. So I wasn't able to disclose that information at the time of the appeal when we went in person.
So to restate the question, who had access at that time?
At the time, I believe, of the takeover?
Of those records that you found subsequent to the hearing?
We recently discovered them. My regional had to obtain the laptop from two previous employees, I apologize, to look through their computer and try to see if there was any additional information that we can discover.
Okay, and just to be clear, there was no record of registration of the unit prior to the 2023?
Correct.
Thank you very much. I see no other questions, and so we will close the public hearing at this time, and we will move into commission deliberations. Do I have anyone who would like to start? Vice Chair Rory.
So I wanted to thank the tenant for coming tonight and the landlord. For me and my fellow commissioners, this is kind of an issue about the registration form itself. And it sounds like there was plenty of notice about the rent adjustments, but really the rule is about having to register the unit with the city, and the policy objectives behind that being to help further the actual ordinance and the process in West Hollywood for all of these rent stabilized units. And tenants receive certain notices, and the city itself can manage the population of rent-controlled units. So, even just assuming that it's an unfortunate situation that in 2010, when the unit was originally leased, it wasn't registered, and they didn't figure that out until 2023 and then registered. That's why the rule is there. There's a reason for it. So my vote for tonight, and subject to everyone else talking and telling me something else I didn't realize, would be to approve that to approve the staff's recommendation, and it's in the spirit of these registration rules, which are separate from the notice rules about the individual rent increases. And then in terms of the amounts, I'm kind of open to hearing what my fellow commissioners think, whether it would be, whether we would entertain some sort of modification of the current recommendation, which I believe is based on the 1,200 number, not the 1,350 number. So I'm kind of on the fence about that. I'll be interested to hear what everyone else thinks. And then assuming whether it's 1,200 or 1,350, whether there's any type of interest in modifying so that it's allowed as a credit based on what council says, because that would be tough maybe for the landlord to have to come out of pocket to reimburse for failing to register so many years ago. I would be open to a credit situation. Those are my thoughts.
Commissioner, can you clarify when you say the credit, you mean credit? Can you clarify what you mean?
What I mean is if we were to approve the staff's recommendation, there would be a total sum due to Ms. Cutler of $13,824 in overcharges. This is based on the $1,200 number. I'm kind of inclined, I mean, that's a pretty hefty sum in itself. So whether that's an actual, they have to pay a check for that amount, or whether they could receive future credit, they could issue a credit and then the rent could be paid against the credit.
Thank you. Thank you.
Do you want to continue, Commissioner Topchin?
Sure. Thank you, Chair. Well, that 1,200 rent that was, excuse me, the 1,200 that was initially used for the calculation, clearly, you know, based on what we heard today, is incorrect. So obviously, you know, the rent at the time was $1,350. That's what I see. Supported by what the parties stated, because I don't see any document here that shows the rent is $1,200. I don't know what the document was used for it, other than that, just a verbal statement by the tenant. So that's the part. That's the part I want to know. Probably, maybe the legal counsel can clarify. So how we're going to do that. As for the reimbursement, which is a Are we okay?
There must be an Amber Alert or something. All of our phones are going off.
Okay.
Silver Alert.
Silver Alert. All right.
That was exciting. Go ahead.
Yeah, after those earthquakes like 10 minutes before, right? We wish. So in regards to that $13,824.11 over charges, as the Vice Chair mentioned. So I don't think the Commission can really have a discussion on how it will be reimbursed. It's an overcharge that has to be reimbursed, but whether it's going to be a rent credit, through the rent credit, or direct reimbursement, I don't know, maybe staff, or whether it's a legal matter, but I believe that's not within the Commission's scope. Other than that, clearly there is an overpayment, and I agree that has to be, the MAR has to be established and the reimbursement issued. So on that, I agree with staff's recommendation. So, but I wanted to hear how we deal with this 1,200 versus 1,350.
So before we proceed, I want to get the answer from our legal counsel, since it's come up from both commissioners who've spoken so far.
Yes, so the municipal code allows for either a rent credit to be ordered or a refund, which would be like a check or something like that. Generally, and how this hearing examiner decided it, is it leaves it silent to that, so it would be up to the landlord and tenant to kind of figure that out. The Commission does have the authority to decide one of those, so the way the resolution is written just affirms that open-ended plan. So if you were to want to do one of the others, we would have to modify the resolution a bit.
Thank you very much. And I saw Commissioner Kirby's hand, and go ahead.
Yeah, I guess to talk about that subject first. So I think in all of our decisions, it's always, whether it's a rent increase, trying to think of the other situation where this comes up. Basically, we've always allowed it to, interest rates. So when the landlord owes you interest rate, it's either they'll pay you, or after a certain amount of time, you can just start crediting it from your rent. I don't think we should treat this any differently. The landlord can decide. It's in the landlord's benefit to pay it off as soon as possible, because they can't increase the rent until the balance becomes zero. So I don't think we should get involved in that decision making. Let the landlord figure that out, and knowing, as long as the tenant understands that from this day forward, or from the day that this decision is final, they have a credit that they don't have to pay for that period of time, because they are owed that money. So I would say let them figure it out, that we should not require any certain one way or the other. When it comes to this case, so I'm concerned that we're in a situation where both the landlord and the tenant are telling us that the initial rent was $1,350. And I understand that initially there was a mistake, about $1,200. But if I look at page 3 of the decision, page 117 of our packet, what concerns me is it says the respondent did not have any copy of the lease. As such, they could not verify if the initial rent was $1,200, which is, I understand that. However, they did verify that $1,200 was the amount of the deposit that was given for the unit. As such, they noted that the rent amount was consistent with the deposit. Well, we've heard testimony this evening that both the deposit was $1,350, which was given to us by the landlord, that number, and the tenant saying that the initial rent was $1,350. So I'm a little concerned that to me, that's a factual statement. So I wonder what the hearing examiner based that upon, and maybe when we're done with this decision, I'm not recommending that we remand it, but I would like a notification or informational purposes to let the hearing examiner know that there was a statement in here that the commission, assuming that there's consensus here, that we're concerned about that statement. I would recommend that we find the hearing examiner erred in the amount that was setting the MAR. The correct MAR should be $1,350 based upon the evidence and the testimony. And I would agree, and then that obviously would create a recalculation that we can let staff figure out. And then I would recommend that we affirm the hearing examiner's decision in terms of the repayment. And I think that covers the issues.
Thank you. Commissioner Topchin, you have more? I moved along before I...
Yeah, if maybe, if you allow just a couple of extra comments. So, actually maybe one even. The repayment, if the commission can state the position or can just, mention that either way through, through rent credit or direct reimbursement to the tenant, will be acceptable, something that will be on the record about the method of repayment. This is kind of for the future. Let's say the management changes, the ownership changes. I don't want the tenant have in the future some sort of legal issues. Let's say the landlord chooses to make monthly reimbursements, and then ownership changes in a couple of years, and there could be potentially a problem with the future owner or manager with the tenant. So I want to avoid that. So I want to have on the record somewhere that whether the tenant or the landlord or can choose to deduct from the rent or get the reimbursement. I understand what Commissioner Kirpis said, which makes sense. It's in the best interest of both parties to have that reimbursed immediately. But what you would say, legal counsel?
It might be a little bit unnecessary, because what the hearing, basically what you're saying in a general sense is whatever is in the hearing examiner's decision is the ruling minus if you vote on the change in the base rent, the MAR. And they just ordered it to be refunded. And so that leaves it open-ended for them to decide how it is. So it already is on the record through the hearing examiner's decision. So I don't know if we need to redo it. You can obviously make that motion and do that if you have a majority vote, but it wouldn't necessarily be needed from a legal perspective.
To this,
A question,
please.
a point of order, I would say. If we don't say anything, the decision becomes final. What happens on, what is it, October 1st, the tenant, it's time for the tenant to pay rent. They have a credit. They don't have to pay rent for up to, sorry, that's not me this time.
It's
You're a little late to the scene. So they have a credit. I mean, it's not a matter of, they don't have to pay.
Correct.
Except that there's a holding period after the appeal for the opportunity to sue, so it would be November 1st, but yeah. Yeah. Okay. None of the new commissioners have spoken up. Who would like to go next? Commissioner Perez?
I was curious, and we don't have to do the math right now. It is? Okay. I was curious about the impact on the remuneration to the tenant based on the adjustment. I imagine it goes up.
So you're talking procedurally, kind of?
Yeah.
Yeah. So there's two ways it can happen. So you have the draft resolutions that were submitted to you the other day. If those are modified, something simple, sometimes I can do them on the fly here. If they're more extensive, generally they would come back at your next meeting. I don't want to influence the math and the votes that you guys take, but there are, from my calculation, 40 months calculated in there. The difference is $150 per month. 40 times 150 is $6,000. Minus that out of the 13,824.11, you get 7,824.11. That would be how I would write it if that was being directed to me to fix it back in the office. And so, do we have the ability to print those out here, the amended resolution? Okay, perfect. So I have both the original resolution and I can change the math as you guys order if you do on the fly tonight. So it wouldn't impact them on this matter.
Thank you.
Thank you. Anything additional, Commissioner Paris?
Not at this time, thanks.
Thank you. I'll turn this way. Anybody? Commissioner Goldman.
If I push and I leave this on, it's on, right?
Oh, yeah.
Okay. Okay, so I agree with affirming the decision and what other commissioners have stated about adjusting the amount due to the correct, the 1350.
Thank you. Commissioner McCafferty, anything to add? Okay. Then I will chime in here and say that it's, I appreciate as the vice chair said, both the tenant and the landlord being here this evening. These are difficult situations, and it's unfortunate that this property manager, who seems like they show up, does not have all of their records from the original lease, and it's unfortunate that everything wasn't filed, and it's not the current landlord's fault, but it's still the arrangement that the tenant has with the property owner. So because of that, it puts us in this awkward situation where from what I'm seeing, the hearing examiner was correct in determining that none of the rent increases were ever legal because there was no registration on file. So with that being said, I just hate that we're in a situation that doesn't seem to be the fault of the property management company that is here, but falls on their shoulders regardless. So with that in mind, I too would support a motion that changed the MAR based on testimony we hear tonight that everyone agrees was actually set at the hearing to $1,350, adjust the amount owed at that time. But I would agree with Commissioner Kirby's that we leave the hearing examiner's decision intact, that the two parties can just determine how that's repaid based on whatever arrangement works best, essentially for the landlord, if they want to write a check or if they wanted to come out of rent on a monthly basis. So I believe everyone has had a chance to speak. Does anyone want to attempt a motion to that effect, or to any effect, actually?
Let me ask another question. Does the commission want to try to do this tonight, or would we have legal counsel prepare the documents and come back at the next meeting? Because if we entertain the motion to modify, that's going to generate the paperwork part of it.
How does legal counsel feel about that question?
I have the revised resolution ready, so prior to your vote, I would just read the changes, which are relatively minimal to the resolution.
So we could make a motion and approve it now, and you're prepared for that?
Correct.
Okay, I can make a resolution to, I can make a motion to adopt the resolution RSC 24-653, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as to application D-4865. Do we need to state with the corrected or adjusted MAR and revised or adjusted amount of the overpayment owed to the tenant?
And then if you get a second, and before everyone votes, I'll read the changes into the record so you know what you're voting on.
Do we have a second?
I'll second.
Commissioner Paris seconds.
All right,
Do we
and
have those
so
changes?
the amended resolution will read, the title will read, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part and modifying in part the hearing examiner's decision as to application number D-4865. And then you will go to page, that's going to be bottom of page 2, it says section 4. The commission affirms in part and modifies in part the hearing examiner's decision for D-4865. The commission finds that the hearing examiner erred in his determination of the MAR and in his calculation of the excess rent, but the remaining hearing examiner's findings were reasonably supported by the findings and evidence in the record, and that is based upon the decision, the record, and the following. And then the only other changes are to C and D. The MAR for the tenant's unit is $1,350. The tenant's most recent rent was $1,593.47. Added the following sentence: the commission finds that the MAR is $1,350, not the $1,200 as found by the hearing examiner. And then D, the landlord has demanded and tenant has paid rental payments in excess of the MAR. The overcharged and retained rent amount is $7,824.11 due to tenant based upon the hearing examiner's decision and this Rent Stabilization Commission determination. The commission finds that the overcharged and retained rent amount is $7,824.11, not $13,824.11 as found by the hearing examiner. The remainder would stay the same as you were given a copy of.
Thank you. And as you were reading that, I just noticed one typo in the title on the word affirming.
That's fixed.
That's fixed. Thank you. We have a motion and a second, and we've heard the changes. Mr. Secretary, may we have a roll call, please?
Commissioner Goldman?
Aye.
Commissioner Kirpies?
Aye.
Commissioner McCafferty? McCafferty.
Aye.
Commissioner Paris?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Rory?
Aye.
Chair Bass?
Aye. This resolution passes, and I think there's something I need to read at this point in time, so. Motion passes. If the parties have any further questions, you can reach out to the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. For the parties who joined us through Zoom, this doesn't apply because you're going to be here for the next hearing, so you won't be placed back in the waiting room. But before we do that, do people need a break at this point in time, or should we move through? Okay, then we're going to move through to, thank you. We will move through to the other appeal, which is, sorry, I'm trying to keep all these notes here, 486, thank you. And we will follow the exact same procedure. So we will start with a report from our legal counsel. If you're ready. I didn't ask you if you folks needed a break, just the commission.
I don't need a break, but I do need 1 second to scroll to that one. We're going backwards on the report. This one is going to be similar to the last. This is D-4846, 1205 North Hayworth Avenue, number 7. And again, this is a case before the commission for an appeal whether the maximum allowable rent was properly determined and whether the landlord accepted and retained rent in excess of what is permitted by law. The tenant has resided in their unit since 2012. The tenant claims that the landlord accepted rent in excess of the amount permitted under the RSO and regulations. They have also requested a MAR determination. The hearing examiner found that the unit's initial rent was lawful, but all subsequent rent increases were in violation of the RSO. The hearing examiner also found that until such time as registration forms are properly filed and all excess rent is refunded, any rent increase is impermissible. The rent registration form was not filed until December 2023, and no excess rent has been refunded at this time. Hearing examiner found that the excess rent charged was $5,884.38, going back to January 2021. The landlord in this case has appealed, asserting that the hearing examiner erred and that they stated that the total overcharge amount in the MAR determination is incorrect. They state that the landlord increased the rents and that those rents increases were permissible because the tenant knew of the increases and agreed to them. Again, in this case, new evidence was submitted that was found in an audit of storage records. Staff's position is that those documents were available, but they just did not look for them. And so it is new evidence that should not be considered. However, to note, the documents, the original lease and a rent increase document do not contradict the hearing examiner's findings, and they don't assist the appeal in question. Staff recommends that the commission affirm the hearing examiner's decision.
Thank you very much. Are there any questions for legal counsel at this time? Seeing none, we will return to the landlord's representative for your testimony. The same rules apply. I know you've already introduced yourselves, but for the record, could you please reintroduce yourself, your city of residence, and then as you begin, let us know how you would like to divide your time. You may begin.
My name is Lisa Young, the General Manager for the Community and Art Norton in the city of West Hollywood, and I will be using the time by myself. In this argument, we did provide a documentation in the appeal that her lease began in 2012, where her rent was $1,250. In September 1st of 2015, the change of terms were issued by the previous ownership, adjusting her rent to the $1,290. In 2019, from the previous ownership, they also sent an additional increase of 2.25%, raising her rent from $1,365 to $1,396. The following transfer of ownership, which was us in October 1st of 2019, we did not send any rent increases until March of 2023, bringing her rent to $1,438.08. Ms. Sargahi, I apologize if I mispronounce it, provided bank statements as evidence to show her monthly rent payments, which she was making accordingly, and we also provided the ledgers, the previous ledgers before the change of ownership recently, and the new ones currently, showing that she had been making the payments promptly and also according to the balance that she was due at the time. And the same records that we provided were found in the archive of all the computers and files that were restored from the previous employees. At this time, we have issued the resident the credit for the amount of $5,884.38 in June of 2024.
Thank you very much. Do we have any questions for the landlord at this time?
Could you follow up on that last part? You issued a credit to the tenant for $5,884 in June of this year?
Correct, yes. Following the first appeal, when we received the documentation for both cases, we completed the credit to their ledger where they have now been credited the amount that was found in the hearing.
Okay. Has the tenant paid, to your knowledge, paid rent since then?
She has not.
Okay. And then focusing, just so I'm clear, you understand the issue in this appeal and the one before is the registration of the property as a rent subsidized, rent controlled unit. Do you have any documentation for this appeal that would suggest that there was a registration of the unit prior to December of 2023 when it was, the hearing examiner found it was actually registered after the vacancy?
Correct, yeah, we don't have any documentation prior to December 2023.
Okay. And you understand how that has to, that's what the issue is for tonight. It's not so much about the rent increases along the way, it's the fact that that registration wasn't properly filed with the city so that the rent increases afterwards aren't valid and legal.
Correct, yes.
You understand that? Okay.
I want to ask, you say you issued a credit. The purpose of the appeal is to nullify that credit, or what is, I just want to understand your thought process there.
I believe my regional filed the appeal. We were trying to ensure that we were showing that we were in compliance with all the rent credits and the previous ownership transfer and change. I believe they were trying to show the timeline of everything that was given at the time. And because we did receive the notice that the appeal was in the resident's favor, we did apply the credit as it was noted on there that she would need the credit added back. And we completed that in June.
Thank you. Any other questions? So I mentioned that you could divide your time without remembering that we don't have the tenant. I just want to confirm for the record, there is no one here representing the tenant?
Correct.
Thank you. So this would normally be your rebuttal time. Is there anything else you want to do with your 5 minutes?
No, that is everything on my end.
Okay. With that in mind, I will close the public hearing and ask the commission if they have questions of staff or would like to start deliberation. Commissioner Kerpes.
I have no questions and seeing none others. I'll start deliberation. And first of all, I want to applaud the landlord for already crediting the money back. I think that regardless of the outcome tonight, that's the right thing to do in most cases. So I appreciate that, and I'm sure the tenant does as well. But I would move the hearing examiner, or move the staff recommendation that the hearing examiner did not err, and the appropriate MAR was applied, and the overpayment has been calculated correctly.
Do I understand that as a motion?
Yes.
Is there a second?
I'll second.
Okay, we have a motion and a second. I would like to ask I would like to provide all of the commissioners an opportunity to deliberate before we actually take a vote on this, though. Any other commissioners desire to make comments? The only thing I would like to add, seeing no one else, is that I do appreciate that the landlord here does appear to try to be doing the right thing by their tenants, and I know that losing the last one and then hearing the motion for this one now isn't necessarily the outcome that you would desire, but I do want to applaud you for showing up, for trying, and it's just unfortunate that it appears in both of these cases, we should talk just about this one at the moment, it's a matter of not having records that go back quite a ways, and it's unfortunate. So I just wanted to say that for the record, that I appreciate the effort. So hearing no other comments, I would ask the secretary to call roll, please.
Commissioner Goldman,
Aye.
Commissioner Kerpes,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Ori,
Aye.
Chair Bass.
Aye. The motion passes. So as you've already heard this, but I will read it again. If the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. And for the parties that are joining us by Zoom, you will now be placed back in the waiting room. If you'd like to watch the rest of the meeting, would welcome you to stay, but you're under no obligation to do so. We'll move on now to item number 10, new business. For new business, we have item 10A, rescission of resolution RSC 23622. Mr. Kessinger, do we have a presentation for the item?
Legal counsel will be giving this presentation. Thank you.
My notes here say that I was supposed to ask you, just so you know.
Yes, 1 second while I get to that. All right. So this is a little bit strange one, especially for our new commissioners. We don't have this ever or very often. So in this matter, last year, there was an appeal similar to what you heard tonight. If a landlord or tenant does not like the result here, they have to go to Superior Court of California. And that is what the landlord did in this case. And it was a kind of wonky legal question of whether a single rent control unit attached to a commercial unit falls within the rent stabilization ordinance and state law. State law kind of provides the parameters of what we can do as a city and how expansive we can make rent control. The requirement is that it has to be 2 units or more. City's argument was that the commercial unit, because they were tied together on one parcel, qualified it as 2 units. Landlord said, no, I'm a commercial unit and a rental unit for someone to live in. Those are different than what rent control and state law allows for. The city lost that argument. And so the judge has ordered us to rescind or undo the resolution that we made in favor of the tenant in that case. And so that is what is before us tonight. We have 45 days from when the judge ordered it. I think that's sometime in early October. So that is what you'll be voting on tonight, and we're available for questions.
Commissioner Kerpes.
First of all, I'm going to ask the interesting question of what if we don't?
So we are under a court order to do so, and we would probably be sanctioned as a city in terms of a financial penalty or whatever punishment that the judge would like to craft as a punishment for not doing that.
Okay, so everyone to make clear, we do not have an option here. Whether we agree or disagree, we have to do this because it's an order by the courts.
Yes, I would say your hands are tied, so whatever dislike of this you have, your opportunity is to state it on the record, but I would say you should vote to rescind so we don't get in further trouble.
And my other question, and just tell me if it's not relevant to well, why did we get ourselves in this situation? And I ask as someone who probably voted for it. I don't recall this situation at all, but to me, the judge's order seems quite clear that this would not have been a property as considered under rent control, but maybe that's just because the judge is wording it in the way he's wording it. So could you maybe explain a little bit of that? Thanks.
Yeah, so his wording, it was a gray area. The city had interpreted it one way. I think, in the law, there are a lot of times where there's no black and white answer. We try, I think, pretty often to be a little bit more on the pro, trying to bring in more units into rent control if it's legally arguable. I can tell you, I didn't argue this case in court. My colleague did, but from his, in speaking with him, the decision doesn't necessarily reflect the energy he got from the judge in the hearing. So there was a spirited back and forth on whether this went one way or the other. And so we always went in knowing it was, a 50-50 chance or some, we didn't think it was a slam dunk. Obviously we wanted to go our way because we thought our rent control argument was correct, but it's an interpretation of state law. And so we're interpreting our code to fit within state law. And he said, nope, you went a little bit beyond what the state law allows.
And my last question is, oh my gosh, I just had it. My last question is, I know this doesn't set a precedent for other cases, it's very specific to this one, but have we identified, and maybe you don't want to give an answer, but have we as staff internally identified other properties that this, if they were handled the same way, would be problematic?
This is a very fact-specific one, so we are only applying it to this property at this time.
Okay, thank you.
Other questions from commissioners on this one?
I did.
I saw Commissioner Paris, and I'll come to the vice chair after that.
Thank you. This is a bit abstract, I think, but my understanding of the order is because the unit in question is not subject to the RSO because it's on a parcel that combines commercial and a private residence?
Not necessarily. If this was a commercial unit with 7 apartments attached, then this would be under the RSO. But it has to be 2 or more units, but a commercial plus a single rental unit doesn't count as 2 or more. But if it was, 7 apartments above, a liquor store or something, then it would, and again, we could get challenged on that, but that one, I think we have a much better argument about. It's not necessarily the commercial aspect of it. A lot of properties are tied to a commercial unit. It's the 2 or more that's the issue here.
Okay, thanks.
Vice Chair? Oh,
Yeah,
Commissioner
well,
Thompson.
just a quick thought. Yeah, if it doesn't set a precedent for any future cases, or we don't have a actually case, and this type of cases, they don't come up, thankfully, hopefully, that often, right? So, was this? I remember the discussion a year ago when we heard the appeal. This was an attached unit, I believe, right? The unit was attached to the commercial space, which I remember we kind of debated here, but. Again, I don't want any hypotheticals or speculations, but should have that unit been detached, the outcome could have been different, probably.
So it's what is on a parcel, which is a legal definition of a plot of land, and so it wouldn't be if the walls are touching or not. That's not the distinction. Okay. It's what is on that plot, which is a single owned piece of land. So you could have, 4 ADUs back there that potentially don't share walls, but are all under rent control. I know you said no hypotheticals, but I gave you one anyway.
So I wonder if that attached or detached played any role in the argument by the council. All right, thank you.
This is a question that I didn't understand from reading the court's decision on the alienability of the unit, and by that I mean the ability to separately rent or even subdivide the residence part from the commercial part. Could you just explain to me, as far as you understand, how that factored into the court's decision? And I appreciate what you said earlier, which I think for everyone listening at home, I think the lesson from this case, or from this judge anyway, is that if it's just a single residential unit that's attached, or I don't know what you're going to say about the alienability to a commercial unit, then it probably doesn't fall within the city's RSO. But I'm just a little clear on the alienability part.
Yeah, so alienability is the ability to sell it separately. And so if something is able to be sold separately or not was part of the decision. I don't think it was the main factor. The main factor in this case was the number of rental units that were there. And so that was the key distinction in this case. Okay.
And my only other question, I think you just alluded to it, but I just wanted to be clear. As far as council is aware, there's no other Rent Stabilization Commission decisions that are currently up on review. This was kind of an outlier. I think you said ever. I don't know if that's correct, but maybe just to clarify how often this comes up and that there's nothing else pending like this.
So yes, it's rare. We do get sued on these things here and there. Generally, we win them. That's why they're not before you. But we probably have a couple a year that go up to the Superior Court. We win the vast majority of them. So this is the first time. And for the new commissioners, I sat in your seat for 6 years, so I was a commissioner myself. In that time, and then in speaking to my predecessor in this seat, who held this seat for about 4 or 5 years, he couldn't think of one either. I did deal with this case in my previous legal career in the city of LA, but we actually won on that one. So it's...
The case or the fact pattern?
It was the same fact pattern, a business below and a unit above, and we won on the argument that it was in City of LA's rent control program and legal. And so precedent is not set by a single Superior Court judge. Their ruling applies only to those facts and those people. It would have to be a case that goes to the Court of Appeal before it would have binding precedent that we would have to apply across the district. But to answer your question, no, there's nothing coming down the pipes like this, and especially not on this odd fact pattern.
Commissioner McCafferty.
I was wondering if this will trigger a requirement to amend code at all, or does it just kind of state because state law trumps it?
This will not. Our code is our code. It was how we are interpreting that code. So going forward, if we see anything like this, it will trigger staff to look at it a little bit differently and whether we, accept these into RSO and those type of things. But the way the code is written was not, we weren't told to amend our code or anything like that by the judge. It was just, you have applied, and what a writ is, which the writ is the document WRIT, is an order to do something. All the writ said was that we needed to rescind this to say that this property is not within the RSO.
Thank you. My question is about the process that gets us here. My understanding, and I say my understanding because you'll correct me if I'm wrong, the city council makes all decisions when the city is sued in this case. So they've made the decision not to appeal this decision from the judge. Is that correct? So we're at a final stage of this.
Don't quote me on this, but I believe it's the city manager and that level. Not everything goes to the city council at this level. But if they're listening and I'm wrong, I'm telling them I'm not 100% on that because I will get angry emails. Do you know in this? Okay, I didn't think so.
But I guess that it still answers my question in as much as we don't have any role in that. Ours is simply to follow the judge's direction because the city leadership has made the decision not to appeal this decision.
Yes, and these type of things do all go through the desk of the city attorney herself. So I don't know the thought process on this one. My guess would be that we read the judge's ruling and said this one is not worth the appeal in terms of the viability of that and the cost involved and the fact that it's so fact specific. So a lot of times on appeals, you want to be setting a broader policy if you're going to be spending the money and the time that it would have a bigger impact. And maybe the thought process on this was, even if we won, it wouldn't do a lot to strengthen or protect rent control in the city.
I trust the judgment of our city attorney and our city council. I'm not questioning that at all. I just want to establish that we have, even if we strongly objected to this, we don't really have a part in that process.
Correct.
Thank you. So having heard everyone, I will move proposed resolution RSC number 24654, resolution of the Rent Stabilization Commission of the City of West Hollywood, rescinding resolution RSC number 23622 and finding 8242.5 Santa Monica Boulevard not subject to rent stabilization ordinance in the City of West Hollywood.
Second.
Mr. Secretary, may we have a roll call, please?
Commissioner Goldman?
Aye.
Commissioner Kirby?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris?
Aye.
Commissioner Topson?
Aye.
Vice Chair Rory?
Aye.
Chair Bass?
Aye. And this resolution passes. Item number 11, items from staff.
No items from staff at this time. Thank you.
Thank you very much. Number 12, do we have any speakers from the public?
Not at this time.
Thank you very much. Items from commissioners. Do we have any items from any of the commissioners? Commissioner Kirpies.
Really items, but comments. First of all, I want to welcome all the new commissioners to their first meeting, and congratulations on your appointments. I look forward to working with you all. I remember when I was reading these cases, getting ready for this meeting, I was thinking, oh my gosh, I felt bad for you guys because those amounts were pretty large that were just given back to the tenants. And really, we had a good situation here where both the previous and the current landlord did the right things and followed all aspects of the law except for the RSO or the registration. So it kind of reminded me of my first case several years ago where we ended up it was before the city changed the rules to where it was from the start of the tenancy. It didn't have 3 years. It was just to the start of the tenancy. So I remember on my first night, I'd watched a few cases, but never seen anything like this. And we were awarding $27,000 to one of the tenants. And as soon as that tenant found out, all the other ones were going to be applying for the same thing in the building. And it was an old building that had been around for a long time. Tenants have been there. So I understand if this made you feel a little uncomfortable tonight, what the ultimate decision was. But it used to be even worse. And the last thing I wanted to say, I think that was... Oh, I just want to thank the landlord who came and spoke this evening. There were a couple of us a couple years ago on the commission that wanted to change the way the city had evaluated their interest rates, because for so long the ordinance was that it had to be the average of like 5 brick and mortar banks here in Santa Monica, and that ordinance was very old. I'm sorry, what did I say? Did I say Santa Monica? I do the opposite when I'm in Santa Monica. I'm always saying I'm from from West Hollywood when I'm representing Santa Monica. So my day job's in Santa Monica. I live here. So in West Hollywood, which always meant that I think we had 7 years straight where the interest rate was 0, even though these last 10, 12 years, we've been able to invest our money online and make money that way. So that's why we made the change to the ordinance a couple of years ago. And since then, we have been, I think this is the second year, maybe third year, where tenants have actually been receiving interest rates from their deposits. I do understand what the landlord was saying this evening, that maybe we did go a little bit too far, but I'd like to first hear from other landlords before entertaining any other changes to the ordinance. But I do understand the tenants or the landlord's argument this evening that maybe we need to relook at that someday. But for me personally, I would want to hear from more landlords that might have situations like this, because this is a brand new rule, and I think that we need to evaluate it after a certain period, but not quite yet. But I want to thank the landlord for showing up tonight. We need to hear from more landlords and more tenants about these types of issues. Thank you.
Thank you very much. Commissioner Topchin.
Yes, I too would like to congratulate our newly appointed commissioners. Welcome on board. It felt like you've been here for a long time, so I just kind of forgot that, but I will be happy to serve with you on this commission. Congrats.
Seeing no other Commissioner Paris, are you reaching for your button?
Yeah, I'm reaching for my button. I wanted to thank you all for the warm welcome and thank Councilmember Heilman for swearing us in this evening. And I wanted to mention, I was here for the last meeting when you guys approved the change in the schedule for the deposits. There was some logic from staff on how we came to that number. how often do we typically, annually? Yeah, so I think that we can take the year and study those impacts a little more before we start fiddling with it again.
So, yeah, the ordinance is the ordinance that dictates how we calculate that. So that was more of a, do we call it a ministerial duty, where we just kind of announce it at that meeting? There is a logic to it. It's laid out in the code. I keep looking at staff, and to correct me if I'm wrong, but I think that we don't want to get into a debate about the process here because it's not on the agenda. But I do think that if I can repeat Commissioner Kirby's, I think that it's well received that if other landlords want to provide comment on this, that they would that would be well received by the commission during public comment. So we go to your point of studying it. And since I'm already speaking, I will just also join in welcoming 3 new commissioners. It is so exciting to have you here. It's more exciting to have 7 seats filled up here, as we've had to cancel quite a few meetings this year for lack of being able to have a quorum. And just, as your chair, I would like to just encourage you, if you're not going to be able to make a meeting, let us know as soon as in advance, because we shouldn't have canceled meetings going forward with 7 of us. And I just think we owe it to the residents of West Hollywood, and I'm just really pleased and excited to serve with all of you for the remainder of this term and into the future. Any other comments from the commissioners? Commissioner Goldman?
I will comment. I'd like to thank all the commissioners for the warm welcome, and I'm looking forward to serving with you all. And I have a question just out of curiosity. What happens if you have to cancel several meetings and people have submitted? Do those just get put on hold for a long time?
Yeah, unfortunately, it does sort of delay the process, and we do abide by a 115-day timeline. So it is important in that sense to make sure we have quorum and can have these meetings for those appeals.
Thank you.
Seeing nothing else, I would like to adjourn this meeting to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on October 10th, 2024 in the West Hollywood Park Public Meeting Room, Council Chambers, right here. Thank you. Good night.
Favorite pet character portraits. Community members were also able to meet Pet Mayor Winnie. Thank you so much for your service. You're already doing incredible work. What's the secret?